David Soble. I'm a real estate attorney here in Michigan. So I'm often asked what's the difference between using a real estate attorney and a title company in a real estate transaction. Well, a title company ensures that a legal title to a piece of property, a piece of real estate, is legitimate. And a title insurance company or a title agent, they search the public property records and they'll verify a property's chain of title. They confirm all liens, what's valid and what's not, and they also ensure the past and present ownership interest in a piece of real estate. Title agents then will issue a title insurance policy for that property, usually for the amount of the purchase price or for the amount of the mortgage. And title insurance will protect the new owner of a property or the lender. And they're doing this to protect against future lawsuits or claims against the property that result from disputes between parties over a property ownership. So you can have parties who are no longer on title, but they may have a claim against the property. So this is what title insurance will protect against. So title companies will also facilitate closings between a buyer and a seller or a lender, and they handle the money that's exchanged between the parties at the closing. They also will file and record the appropriate real estate documentation with the county records, or what we call the county recording office, and they also will coordinate with the municipalities as well. So a property transfer affidavit will be filed with the city, not with the county. But issues regarding a valid chain of title, they pop up on a regular basis. And while a title agent may have experience in how to correct many minor issues, they really don't have law degrees, and they cannot provide legal advice to parties in a transaction when more serious legal issues arise. And these title issues will affect ownership rights. So who do you call? Well, that's where attorneys, real estate attorneys, come in. And realtors, as well as buyers and sellers and lenders, they benefit from working with attorneys, since the attorney can not only review the purchase agreement, but they can also answer legal questions concerning the contract or the negotiations, or how whatever the contract terms are, how that might even affect a property's title. And attorneys are the only ones that can give a legal opinion on how a party can hold title to a property. So there's many questions that come up, and so many issues on a regular basis. Questions such as, what's an acceptable exemption or exception to a title policy? Or what's your legal obligation to your lender when you're closing on a transaction? What are the legal rights of the buyer or the seller? And very common, I'll get issues with what we call restrictive covenants in a deed. Which covenants or which promises are valid and which aren't? And what if a title to a property is clouded? That's something that only an attorney can really give a good answer to, a legal answer to. Also, will an escrow holdback affect the legal rights to either party? None of these questions can be answered by a title agent or a realtor, only by a licensed real estate attorney in the state in which the property sits. So obtaining title insurance is required if you're going to go get a mortgage, or if you're going to go sell a piece of property to a buyer who wants to make sure that you are the actual legitimate owner of this property. But getting a real estate attorney is not mandatory. Where title insurance is not optional, it is optional to have yourself a good real estate attorney review your legal documents before you close. And you want to have that to prevent legal problems in the future. So while it may be optional, it really should be a mandatory item on your list when you're buying or selling a piece of property. I'm David Soble. Thank you very much for joining me. And if you have any further questions, comments, or concerns, you're welcome to call me at 888-789-1715. Thanks for watching.